They don't. They don't exit now. Well, once it's taken care of.
Good grief, I just wrote 2023. 2028? At least I'm making us younger, not older. First. All right, ma'am. Good morning. Are you Melissa Taylor? And will your client waive the formal reading of the indictment in each case?
So waived.
I'm going to take judicial notice of the court's file. Ms. Taylor was evaluated for competency to stand trial. Dr. Capon did that evaluation. I've received the report dated May 22nd of 2025 with the finding from Dr. Capon that Ms. Taylor is currently competent to stand trial. Is there any other evidence with regard to competency?
Your Honor, I can only say that evidence a couple of times out of the jail again this morning, and I believe this is.
All right.
I can't say that there's no evidence of no incompetency. There's one time the evidence, there's been none that I was aware of. She's currently.
All right, and Mr. Nichols.
Nothing to add, Your Honor.
All right, then, based on the report and Mr. Kimmler's comments, I am going to find Ms. Taylor currently competent to stand trial. Now, Ms. Taylor, in cause number 24 DCCR 2177, you're charged with second-degree felony.
The judge just ruled that Miss Taylor is competent to stand trial, despite her attorney expressing doubts. That matters more than most people realize. Competency isn't about whether someone has mental health struggles. It's about whether they understand the proceedings and can assist in their defense. And once a judge makes that call, the case moves forward full speed. Now, here's the real question. If even her own attorney believes she's incompetent...
Offense of assault on a peace officer from October 2nd of 2024, how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? All right, and in cause number 24, DCCR 2311, you're charged with the state jail felony offense of credit or debit card abuse from October 2nd of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they've charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimmler?
I did.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a cap of 5 years in the assault on a peace officer case. And then whatever happens, I guess you're pleading open on the other one as long as I run them concurrently. Okay, so in essence, a cap of 12 months then?
Yes,
With everyone's permission,
yes.
Can I make that? Let's see. So it would be a cap of 12 months on that state jail case. Do you understand?
And that's for...
No, it's for a credit card. So what that means is that if we go forward this way, you're leaving your punishment up to me. And as long as I don't give you more than 5 years in the assault on a peace officer case and 12 months on the credit and debit card abuse case, then you're waiving your right to appeal. I can give you 5 years. I can give you less. It'll all be determined when I get the information at a sentencing hearing.
Should the court lean more cautiously or trust a formal evaluation? Let me know what you think. Notice how the judge walks her through it carefully. Are you pleading freely and voluntarily? That's not just routine. Courts have to create a clean record, so the plea can't later be challenged as coerced. But here's what raises the stakes. Assault on a peace officer is a second-degree felony. That's serious time.
You have an absolute right to have a jury come in and determine 2 things. The first would be to decide if you're guilty or not. And then if they find you guilty, you could leave your punishment up to them. If we go forward this way, you're waiving that right and leaving it up to me with those ranges that you've agreed to. Is that what you want to do?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1 in each case.
Okay.
It's admitted in each case. All right, ma'am, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Again, find that you're mentally competent and understand the nature and the consequences of your pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we will come back later for sentencing. Anything that you think is important for me to know, be sure to give that information to Mr. Kimler. He'll present it to me on your behalf when we come back. All right?
I do have a letter.
If you'll just get that to the clerk, please. All right. Thank you, ma'am. You can go back with the bailiff. All right. Good morning, ma'am. Are you Peyton Woodruff? What is happening? Everything. Oh, no. All right. Will your client waive the formal reading of the indictment in each case?
She will.
Ms. Taylor and I'm sorry, Ms. Woodruff. Excuse me, Ms. Woodruff. Did I not? Hold on. Did I not send you both of those documents on Ms. Taylor? Okay, there it is. Back to you. All right, now. Okay. She'll waive the formal reading in each case. Ms. Woodruff, in cause number 24, DCCR 1710, you're charged with the state jail felony offense of burglary of a building from June 30th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? And cause number 25, DCCR 0426,
on the table. When someone pleads guilty this quickly, do you think it's strategy, remorse, or overwhelming evidence? The judge is ordering a pre-sentence investigation report, also called a PSI. This is huge. The probation department will dig into her background, criminal history, mental health, employment, family support, everything. This is where mitigation lives or dies. Sentencing won't happen today. And sometimes that waiting period is more nerve-wracking than the plea itself. Imagine going back to a cell not knowing if you're about to get probation or years in prison.
You are charged with the second-degree felony offense of robbery from February 22nd of 2025. How do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In each of these cases, I have here on...
Wow. Here's a big moment. Miss Woodruff is entering an open plea, meaning no deal was made with the state. That's bold, because it puts everything in the judge's hands. She's waiving a jury and leaving her sentence entirely up to the court. Do you think taking that risk could backfire? Or is it a smart legal move?
Computer documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler? Do you fully understand them? And it looks like there is no agreement. This is just open plea to the court. Is that correct? Do you understand that a plea of guilty or no contest, if you're not a U.S. citizen, may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Also, want to make sure you understand you have an absolute right to have a jury come in and determine two things. The first is you can let them determine, obviously, if you're guilty or not. And then if they find you guilty, you can leave your punishment up to them. If we go forward this way, you're waiving that and leaving your punishment up to me. And is that what you want me to do? All right, state tenders number 1 in each case. It's admitted in each case. Is there any evidence that Ms. Woodruff is not?
The judge decides to reset the cases for a pre-sentence report, which is huge. This gives the probation department time to investigate and provide a recommendation. It's a suspenseful pause in the process. The final sentence isn't coming today. If you were in court, how would you feel waiting for that report to decide your future?
You're out counsel. Several occasions.
All right, then at this time, Ms. Woodruff, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we'll come back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Kimler, and he will present it to me on your behalf when we come back. All right, you can go back with the bailiff.
Not if I may. She has bond that was increased.
I'm not going to consider based on that plea agreement or the lack of a plea agreement.